Okay, good morning, everyone. This is the Town of Ocean Ridge Special Magistrate Code Enforcement hearing for Tuesday, October 1st, 2019. It is 10 o'clock for the record. We'll start if we're ready. Item A on the agenda today is the adoption of the previous meeting minutes, which are from August 6, 2019. I reviewed those, and I'll hereby adopt those this morning. My name is Amity Barnard. I'm the special magistrate for the hearing this morning. Looks like we have two fine assessment hearings on the agenda. The cases will be called in the order in which they appear on today's agenda. Once you hear your agenda item called, if you could appear at the podium, step up to the podium. The way this will work for fine assessment hearings is that the town will present their side of the case first. Once they're finished, you will have a chance to stand up, cross-examine any witnesses that they have put forth, ask any questions of the town, ask me any questions, tell me anything you need me to know as I'm considering these cases. Once we're done with that, the town will ask for remedies, seek remedies. We'll go through the whole process for each case. If you have any questions as we proceed, if your first time here at Code Enforcement, please feel free to stop me along the way, ask anything you want to know. This is a quasi-judicial hearing, so that means the formal rules of evidence do not apply. However, all testimony today is given under oath, under penalty of perjury, under the state of Florida's laws. So first thing I'm going to do is I'm going to swear everybody in. If you're here to speak on behalf of any item on today's agenda, if you could rise and raise your right hand for me. Can you stand up, please? Thank you. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Hearing that, the town can proceed.
Yes, Your Honor. On the first one, case 2019-004A, Brookshore Limited, 6009 North Ocean Boulevard. This, if you remember, at the August 6, 2019 special magistrate hearing, where we had the fine assessment for the first part of the violation, because going back a couple of months prior to that, there was a two-pronged violation, or a two-pronged, I guess, they had to meet two steps in order to be in compliance. One was they had to pull the building permit within a certain period of time. And if they didn't do that within the 30-day period, we would start the fine running at that point in time. If they did meet that, but they didn't demolish the structure, I think within a 90-day period, then we would go ahead and at that point in time come back to you to say, okay, they failed to comply with that part of it. And we would come back in front of you for a violation hearing and a fine assessment hearing for that. I guess I'm kind of asking the special magistrate's opinion on this, because in looking at it, there's a fine running now. They failed to pass that first step.
Go ahead.
Okay, we aren't really looking to, I don't think we can hit them with another fine for the same violation for missing the second step, because you have to complete the first step before you get to the second step.
Right, and so is the status of the case that the permit has still not been issued?
Correct.
So
yes.
The first test has still not been satisfied.
The fine is still running, and I guess procedurally, I was just trying to think of the best way to to address something like this. I think we could go ahead based on that. I think what we could do is we could go ahead and get a rule, a fine assessment from you saying, look, they have not complied with the next step. If and when they get a permit and they are not able to complete the demolition within a 90-day period after obtaining a permit, then the second fine assessment would possibly kick in, or we could bring it back in front of you at that point in time. See what I'm getting at? I don't know if we want to try to get a ruling now from you for something that hasn't happened, or it may or may not happen.
Yeah, and the issue is going to be how the original order was structured, and I believe the 90-day timeline on step 2 in terms of demolition was not contingent on obtaining the permit. That was just a set 90-day period. So
correct.
My preference, and I think how we ought to proceed, is we ought to give a status today, and if they are in fact in violation, they have not complied with that 90-day timeline, that needs to be found today. We will not start a new fine running. There is already an existing fine running, but perhaps the respondent can give us some more detail as to when compliance is expected.
Very, very good. No, I was just kind of procedurally trying to figure out how to how we need to proceed on this, because they haven't complied with those steps, so.
Right, and my concern is that the 90 days was not tied or was not in any way contingent upon issuance of the permit, so I think technically they're in violation. If the testimony
Yes.
today is that they have not demolished the structure, then technically they're in violation of that.
And I will let Mr. Cameron kind of testify to that. I guess, has the
Correct.
structure been, has any permit been applied, any structure, you know?
No, we have not made any progress. And the structure has not been demolished, correct.
Okay, and where are we, or where is the respondent in terms of permit issuance? What, as I recall from the previous hearing, they applied.
The respondent needs to provide everything that's necessary to get the permit and haven't done it at this point in time. And-
Okay, so it's just an
and so the
incomplete.
delay is on them
Okay.
to provide that.
I guess if I can, has any other paperwork been submitted or documented or anything issued by the town since the last hearing?
No.
Okay. And I do know that
And the
Ms.
applicant, he
Yeah,
is here to.
Mr. Brito is
provide-
here
to
to-
provide testimony as well.
Do you want to approach the podium? Sir, thank you. And can you state your name for the record, please?
Ron Brito with Enterprise Contractors Incorporated.
Thank you. Can you provide an update?
Yeah, basically, we've applied for the permit, but the application needs to has some procedural things that need to be done first. The utilities need to be shut off on the property, and that can't be done as of yet. So we're waiting for, we've been waiting for a closing to happen, as far as there's been a hold put on his funds for 5 years. Has been on there, and he's been working with the lawyer to get all the holds off. All the holds have been released. The funds have been deposited into his lawyer's account. His lawyer's ready to issue a check, so upon issuance of the check, we're trying to get confirmation today or yesterday or this week. And Roshana Holiday kind of affected the lawyer, so the lawyer can't get us any documentation. So if we had another week, we could come in, we'd probably have the application applied for, and everything should be taken care of by then. The money is in his account, so we're actually just waiting for the funds to transfer over from the lawyer to the client. So that's basically where we're at right now. And are we compliant with the application? Not as of yet, but it would take a couple days to get that resolved. We have to get the water turned off and the electrical turned off.
Okay, and
and
then
that
what
would
is,
be it.
what is your timeline for demolition? Once you get permitted?
Demolition will probably take, if you give us 90 days for the demolition, from the time of permit, we could have it all taken care of.
Okay, so the issue, and I believe we talked about this at the last hearing as well, but at the violation hearing, it was your testimony at that hearing that you could obtain a permit within 30 days and demolish the structure within the 90
Yeah.
days.
Yeah.
So unfortunately, where we're at now is a fine, you've been found in violation and a
Yes.
fine has already started
Yeah.
running because of your
We're
failure
aware
to
of that.
comply with the 30-day restriction or requirement. I can't give you at this moment, we're past the point of additional time. You're already, based on your testimony today, in violation of that 90-day
Yes.
demolition.
Yes.
So
Yeah.
what's gonna happen is, I'm gonna find today that you have not complied with that second prong, that 90-day compliance timeline. As the town attorney indicated, an additional fine won't start running. A fine is just already running on this
Okay.
violation because you didn't pull the permit within the 30 days. So that fine is going to continue to run until you achieve compliance. Now, compliance will mean both things. You have to ultimately get the permit issued and also demolish the structure.
Correct.
That fine is already running in an amount of, I believe it was $200 a day, yeah. So, that's gonna add up quickly, so
Yeah.
time is certainly of the essence for you and for your client. Unfortunately, where we are now, the fine is already running, so there's nothing I can do here today that will alleviate that for you. The best advice I can give you is to do everything you can to expedite getting that permit issued and getting the building demolished
Yes, he's
as
aware.
quickly as you can.
Yes, he's aware of the
Okay.
fine, that it is compounding daily.
Okay,
And believe me, he wants out of that house more than you guys want him out. So it's just a matter of just some funds changing hands and getting everything in line with the city, so.
Okay. And the only other thing I'll say is that as soon as you have achieved compliance, make sure you communicate with the town. I'm
Yes.
sure, given the size of the town, they're gonna know when this begins, but certainly communicate so that you can get an affidavit of compliance as quickly as
Okay.
possible once you have
Yeah, I'll keep in
complied.
touch with Mr. Cameron.
Sure. So in case, do you have anything further? Any other
No, that
questions for
should
me?
be it.
Okay, thank you, sir. In case number 2019-004A, I'm going to find that notice is sufficient. The respondent had actual notice of today's hearing at the previous hearing, and the notice documents are also sufficient. I'm going to find that the respondent continues to be in violation for failing to now have demolished the structure within the 90-day timeline provided in the previous order finding violation. So I'm going to not assess an additional fine today, but I'm just going to find that the violation continues to exist, the fine continues to run, and it will run at the previously imposed fine amount of $200 per day until compliance is achieved. I'm also going to assess costs for today's hearing.
I think it's $176.85.
Yes, sir, in the amount of $176.85,
And if those could be paid within 30 days.
payable within 30 days.
Can I say something? The fines from the last hearing have not been paid.
Okay, so I will also reaffirm the administrative costs, any administrative costs imposed at the previous hearing. I believe they were in the amount of $386, so I'll also include those in the new order as
Yes.
well, just to maintain the files for the town. Anything further from the town?
No, Your Honor.
Thank you. And sir, as it has been the case in the past, you will get an order, your client will get an order in the mail with the results of today's hearing, so stated. And with that, we'll go to the next case.
Yes, Your Honor, this is case number 2019-004B, Patrick F. Scanlon Residuary Trust and Patricia Scanlon, 11 Coconut Lane, Ocean Ridge, Florida. And the violations were 30-173, 67, 174A1 of the town's Code of Ordinances for not maintaining the pool and spa. At the prior hearing in August, Your Honor found that there was a violation that did exist where these sections of the code were violated. And at this point in time, I'll turn it over to Mr. Cameron to inform you of what I guess he has or has not been able to find on the property.
Good morning, Your Honor. As of Friday, the situation has not corrected itself. However, I did speak with Patricia, and she is here to give testimony. She intends on remedying this matter. So I'll turn it over to her to speak at this time.
Good morning.
Good morning. Can you state your name for the record?
Patricia Scanlon.
Thank you, ma'am.
So I am making every effort that I can to try to remedy this situation. I've shocked the pool so that hopefully that should at least take care of any major problem with it. I'm working on I've had contacted several contractors already, and hopefully I'll have someone soon that can take care of the entire problem.
Okay, and what is the town's position with regard to this case?
We're willing to work with the client, whatever, as far as allowing an extension, giving her the opportunity to get a contractor to fix the pump and fix the whole circulation system. And thank you for putting the chlorine in it. That helps to minimize the mosquito threat. So, but in lieu of that, it does need a pump system in place because you have stagnant water. But yes, I'll be willing to extend time, 2 weeks, I guess.
I'm not going to be here. I think I probably need a little longer than 2 weeks, maybe 30 days. That's
We're fine with 30
possible.
days.
I guess, Your Honor, then if, she's been found guilty, she's requesting an extension of 30 days, which I think the building official is okay with that. I don't know if you can structure the order to have the fine commence if it is not, if compliance is not achieved. I guess my concern is, I'm not sure if we're going to have to come back in front of you again in order to say, okay, look, she's still not, and maybe that's what we do. Maybe we continue this, this hearing until next month. At that point in time, and then you hear back from the building official, and if compliance hasn't been achieved, then at that point in time, we initiate conclude the fine assessment hearing, but I'll leave that to your discretion.
Yes, we can certainly grant a continuance and set a new compliance date, which could be a couple of days prior to the next hearing, in order to ensure that we can verify the status of compliance prior to the hearing.
It looks like November the 5th is the next code hearing, so maybe if compliance, if we give Ms. Scanlon until November 1st to have everything completed to be in compliance, then I think we can live with that. Right, but, and at that point in time, maybe if your order can reflect that if she is in compliance, then we do not need to meet at that point in time.
Sure, the order will state that if compliance is achieved prior to that compliance date, that the appearance at the fine assessment hearing will not be required.
Okay, and we do have admin costs for today's hearing too, in the amount of $176.85, so.
Okay, and anything further from you, ma'am? You think 30 days that you can make that timeline? You'll do your best to make that?
I will do my absolute best.
Okay. Okay. It sounds like the town here is being very gracious and attempting to work with you.
Yes.
So in case number 2019-004B, first I'll enter into the record Exhibit 1, which is evidentiary case file. I'll find that notice is good and sufficient as the respondent is here, and the notice documents indicate that service was proper for today's hearing. I will find that the respondent continues to be in violation of sections 30-173 and 67-174A1 of the Code of Ordinances. I will grant an order granting continuance, setting a new compliance date of 11/1, that's November 1st, or appearance at the 11/5, November 5th fine assessment hearing, or imposition of a fine in the amount of up to $250 per day if compliance is not achieved by that November 1st date. And as was stated, so long as you comply by that November 1st date and have the town sign off on that compliance and give you an affidavit of compliance, your appearance at the November 5th hearing will not be required. I will also assess administrative costs for today's hearing in the amount of $176.85.
And if we could,
Payable within 30
well,
days.
if we could have those paid by November 1st as well, so that way everything, hopefully everything could be resolved by November 1. And I just want to make sure that Ms. Scanlon understands, this is your notice for the November 5th hearing. You won't be receiving anything else from the town. We're just giving you notice now that November the 5th at 10 a.m., that's the fine assessment hearing will continue at that point in time. So unless you've got confirmation from Mr. Cameron that compliance is achieved, you will need to be here.
I understand.
Okay.
And the order that you get in the mail will have both those dates in it, so you'll have written notice of that as well. So again,
So I will receive notice.
Well,
I will or
you'll
will
receive
not?
you'll receive the order in the mail. I'm just saying you aren't going to receive separate, notice, hey,
you won't
that's,
get a separate notice of hearing for that
Right.
hearing.
I understand.
Yeah,
yes.
you're being
I
given
understand.
actual notice today
Right.
at the hearing today for that November 5th hearing.
Okay.
So again, those administrative costs will be payable by 11/1/19. Thank you.
Okay, thank you.
Anything further from you?
No, Your Honor, I think that's it.